words can't really describe.
Yeah.
I'm happy, thrilled, upset.
We're just glad justice was served, that he got what he deserved, even though we can't have my daughter back.
Welcome back. A jury in Florida found defendant Keith Johansen guilty of first-degree murder for murdering his wife. The group of 8 men and 4 women deliberated for just under 3 hours before reaching their decision. Here's how it played out in court.
In the Circuit Court 7th Judicial Circuit in Fort Flagler County, Florida, State of Florida versus Keith John Johansen, case number 2018-426 CFFA, Judge Christopher France. Verdict. Count 1 of the indictment. We, the jury, find the defendant, Keith John Johansen, as follows to count 1 of the indictment. Guilty as charged as the crime of first-degree murder. So say we all, dated at Bunnell, Flagler County, Florida, this 28th day of October, 2021, 4-person.
Would other side like the jury poll?
Yes, you are.
Madam Clerk, please poll the jury.
Juror number 1, is this your true and correct verdict?
Yes, ma'am.
Juror number 2, is this your true and correct verdict?
Yes.
Juror number 3, is this your true and correct verdict?
Yes.
Juror number 4, is this your true and correct verdict?
Yes.
Juror number 5, is this your true and correct verdict?
Yes.
Juror number 6, is this your true and correct verdict?
Yes.
Juror number 7, is this your true and correct verdict?
Yes.
Juror number 8, is this your true and correct verdict?
Yes.
Juror number 9, is this your true and correct verdict? Juror number 10, is this your true and correct verdict?
Yes.
Juror number 11, is this your true and correct verdict?
Yes.
Juror number 12, is it true and correct verdict?
Yes.
Johansen was sentenced right there by the judge, life without parole. Following that verdict, prosecutors Jennifer Dunton and Jason Lewis spoke about their reaction to the jury's decision and how they approached this murder case.
We're very happy, obviously, with the result of the jury. I think juries usually get things right, and of course they did in this case.
I think the evidence actually played out much more favorable even than we had anticipated. When he took the stand, I think he was a callous, very cold individual who did not relate well to the jury. And then he got on the stand and he lied. Again, another lie. So I think that was very helpful for us. And the very fact that he got on the stand and told a different story than he told to Mr. Buffington, than he told to everybody else. And the fact that he wouldn't really make eye contact with the jury, he was probably the worst kind of defendant to put on the stand, one that just garnered no sympathy in any way. What you find is, Ms. Dunton's been doing this over 16, 17 years. I've been doing it over 20 years, is that juries are not legally trained. And reasonable doubt is a very confusing instruction no matter where you're at. And frankly, to lawyers, it's still confusing. So, the jury goes back there, they're not sure, and sometimes they want more clarifying questions. And generally, the biggest, obstacle is getting them to go back and read the jury instructions, which will basically explain and simplify the process for them and understand it. We get questions like that where we look at ourselves and we're like, that's a very unique question that we didn't expect. I think what might have happened in this case, there might have been maybe 1 or possibly 2 people who were maybe holding out and weren't really sure, and they needed to go through the deliberation process to explain the law and apply that to the facts.
I'm happy that we were able to bring closure and bring an end to this part of, obviously, the grieving for the family, and that we got justice for Brandy Salenza and her family.
Still with us, Magistrate Judge Kimberly Bando and Criminal Defense Attorney Jeffrey Wolf. Kimberly's in Atlanta, Jeffrey in Denver, Colorado. This process, like they're just referring to the reasonable doubt scenario. We watched this trial unfold here on CourtTV, and this was one of those trials where you thought, okay, that might be a 5-minute deliberation because of the collapse of the defendant on the stand and just the unbelievability of it. But Kimberly, they took 3 hours, and as the prosecution said, you get back there and you can think of reasonable doubt. What does reasonable doubt mean? At the end of the day, it did work out the way it should have, I would argue. All of our viewers would agree. But talk about this kind of hurdle that everyone has in every trial, whether you're on the state or the defense side, but mainly for prosecutors, this bar of reasonable doubt.
Yeah, so I've been on both sides of that. And so the way I explain people is that you may actually have doubts, but are your doubts reasonable? Like, could this have possibly happened? And so you have to go through with them and explain what they believe is reasonable, which is why it's important to kind of go through that when you weave it into your voir dire when you're picking a jury, so you can kind of plant that seed in them to begin to understand like what they're looking for. Like I may have a doubt, but is that doubt a reasonable doubt that a reasonable person would have that would make me believe that this person is either innocent or guilty? And if I have a doubt and it's a reasonable one, then I have to find that this person is not guilty. So you as the defense attorney and as the prosecutor, you have to kind of make sure you spend time with that because I've realized, well, I've learned through experience, if you don't, it can come back to bite you.
The victim in this case, Brandy Salenza, only 25 years old. After the jury came back with the verdict, her sister addressed the court and addressed the defendant.
So, Lindsay, if there's just something that you want to say before the court imposes sentence on behalf of the family, you can do that now.
Brandy wasn't just my sister. She was my best friend. She was a mother. She was a daughter. She was young. She still had a whole life to go. And he just took her away and nobody was able to say anything. And being in jail is great for freaking him. He gets to live, as we still have to suffer inside with my sister gone and knowing and have to deal with Rylan growing up knowing his mom is not here with us. Thank you.
Always emotional. Jeffrey, the decision was made in this case to put the defendant on the stand. When he got up there, he told a different story that he told investigators, a different story than he told his parents, different story that he told the defense expert in this case. And the story sort of aligned with the physical evidence for the first time, but it didn't align with reality. Talk about that decision, bringing your client up onto the stand. It is rolling the dice big time, is it not?
It absolutely is. The most important thing to understand about the decision for the defendant to testify is that it is the defendant's decision. The attorney gives advice, but oftentimes there can be disagreement there, and when there is, what the defendant says goes. If you need your client on the stand and they don't want to get up there, they don't have to, and vice versa. So what I will say about this case in particular is that once this guy made this decision to give a story to 911, to give a story to the expert, to give a story to his family, and have the wherewithal to delete some of the camera footage, but not all of the camera footage, and then that camera footage shows that he is absolutely lying to 911 when he's talking to them, because he is in a separate part of the house hiding drugs instead of trying to resuscitate his wife. And so once that happens, the story had to change. But why the defense didn't have this story as the entire case and weave it in throughout and just let him get up on the stand and try and sell this new version of the story, that I don't understand. Because once he's made the decision to get up there and testify, and he's going to give this different self-defense story versus the self-inflicted gunshots that he had told everyone else, I just don't know how you let that happen. I don't know how you let yourself ride two horses. I wish I could understand how that occurred to this defense attorney, because it was horrible decision making.
Yeah, well, let's listen to the defendant trying to explain away the reason that he didn't provide CPR to his wife, who the 911 operator was telling him to try to save. Listen.
When you told the detectives you were sliding around on the ground and you couldn't get to her, that was a lie.
Well, I was a little bit wet, but that was a lie, yes.
Okay, you didn't try to get to her.
I got to her.
You got to her?
Enough to see that she wasn't breathing to call, the proper authorities.
Right, but you never tried to help your wife.
I don't know CPR. I'm not trained in stuff like that.
What about when the dispatcher's out telling you what to do and trying to give you instructions? You never touched her, you never applied pressure. That's true, correct?
That's true. I didn't know where the wounds were.
You told the dispatcher you saw blood spots, correct?
Right.
And when he asked you to apply pressure, you said, I don't want to touch her, I don't want to get near her, correct?
Correct. I didn't want to hurt no, you know.
And so again, you told the detectives you didn't see a wound, you didn't see where she was shot. That wasn't true.
I didn't see no bullet holes. I just saw a little bit of blood.
But you knew you shot her twice.
Correct.
So you lied.
Well, I didn't see a bullet hole, so
You saw blood.
correct.
And you knew you shot her.
Correct.
And when they asked you where do you think she was shot, you lied and said, I don't know.
I didn't really know.
Kimberly Bando, it's just, when you're at that point, it's difficult to get yourself out. What about the prosecutor? Your thoughts? I mean, she seemed to do an excellent job of, with that staccato style questioning, basically giving him no out.
Yeah, she did an excellent job. She basically put him a trap and set it up, and he fell into it every single time without hesitation. It was cringeworthy, and I just was shaking my head the entire time watching it. Like, why is he up here? Why is he testifying? He would have did better just sitting down at the table. It was horrible. And
maybe if he wouldn't have taken the stand, maybe he gets lucky and they don't get him on first with the premeditation. We'll never know. Coming up, the children of a housekeeper who worked for embattled South Carolina lawyer Alec Murdaugh filed a motion for his arrest and detention until the money that he allegedly embezzled from her estate is returned. We spoke with the attorney of the estate of this woman here, Gloria Satterfield, the housekeeper who died at the Murdaugh home. We're going to talk about that with him next on CourtTV.